authorized by law.
Your Honor, I take very extreme exception for Ms. Youngston coming up here and trying to impugn the reputation of my colleague. If I had to list out the number of cases,
all right, Mr. Groman, let's keep us on track. I'm not going to consider it. It's not part of the record.
Your Honor,
right now.
my colleague was, and this is broadcast live, and that's
you can respond to it on your own. Mr. Grubman, please let me finish.
Okay.
It's not going to be part of the consideration right now. If you want to handle that outside of the courtroom, that's your business. But for now, to stay focused, I think we should just focus on the law.
Respectfully, Judge, though, it was said on the record, and I think I should have the opportunity, and Mr. Aurora should have the opportunity to respond, because that was completely inappropriate. There have been many times that the Fulton County District Attorney's Office, including some of the members that are sitting in the courtroom today, have been called out by courts by name with inappropriate things that they do in the grand jury and at trial. So no, I cannot take Ms. Young's word for it that it was done properly. Ms. Young's trying to send my client to prison, and we have the right to know if it was done properly. And she keeps saying there's no case law. As Your Honor said, there is case law. Instead of creating these wonderful PowerPoints that they're so fond of, read our briefs. The Collin case says we can talk to grand jurors. So the fact that she got up here and lied to the court.
All right, Mr. Grumman, I think we need to go down that road.
Your Honor, she lied to the court, and I apologize, and she defamed my co-counsel.
I've said it's over.
All right. Well, I wish you would have stopped her from defaming my co-counsel.
So where we are, let me just summarize. With motion number 1, with the motion to speak to the grand jurors, I would ask defense counsel to supplement their motion. We can do this. I don't think it needs to be, since this is something that would be crafted and considered, we can just do this off the docket. We can do this through email, but just a proposal of the questions, the topics that would be gone into, and if we need to follow this up with another hearing to actually hone those, we'll do that. But I think for each question or subject matter you go into, I'm going to want to see a citation for how this is an actual relevant line of inquiry. All right, and then we can get into the logistics from there, because I think there's a way to accommodate the case law cited by the state about the general secrecy, but still allowing the defense their ability to make sure that the grand jury fulfilled its duty in a manner recognized by law.